Welcome to the Call to the Bar, International Law Over Drinks, a series of informal conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm your main host for today, Dr. Ntina Tzouvala. I am an associate professor at UNSW, and today I'm joined by Call to the Bar co-host Juliette McIntyre, who is a senior lecturer in law at the university in South Australia, as well as our resident procedure goblin. We're also joined by Dr. Victor Kattan. Dr. Kattan is an assistant professor in public international law at the University of Nottingham. His expertise encompasses the legal aspects of territorial disputes, the history of international law, including the law of the United Nations, as well as international humanitarian law and the use of force. He combines scholarship and practice, and he has given evidence as an expert witness before the UK's House of Commons Foreign Affairs Committee on the Israeli-Palestinian conflict, and he has also appeared as an expert before the UN Human Rights Council's working group on the right to development. Just yesterday, in fact, Victor was part of a 4-person delegation that presented a 400-page, 400 legal petition to Sir Keir Starmer's office at 10 Downing Street, requesting reparations for British violations of international law when it was the colonial power in mandatory Palestine on behalf of 14 petitioners harmed by Britain's actions. This will become relevant because Victor and Juliette are joining me today to talk about judicial impartiality, recusals, and legal ideology at the International Court of Justice. But before we get to any of this, Victor, Juliette, what is your drink of choice for today/tonight?
Well, I'm having a double espresso because it's still the morning here.
Sensible.
Excellent choice. Well, look, we've had actually a lovely spring day here in Adelaide, so I'm having a beer, and it's a Japanese one because I don't drink Australian beer. It's gross. So yeah, it's very nice.
And I am being more sensible. I am having a ginger and lemon tea, even though it is the evening in Australia. So it would have been perfectly sensible to also have a drink. Okay. The reason I am talking with Victor and Juliette today is because in late August 2025, ICJ Judge Julia Sebutinde, who is, as this podcast listeners know, no stranger to controversy, delivered a speech at Watoto, I hope I'm pronouncing this correctly, church in Uganda. During this speech, she referenced her dissenting opinions, both in the ongoing case of South Africa against Israel concerning the Genocide Convention and Gaza, as well as the ICJ's advisory opinion on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. In particular, she was reported as saying, quote, "The Lord is counting on me to stand on the side of Israel," end of quote. The statement has since provoked considerable outcry amongst both professional international lawyers and amongst, I would say, the general public. And we have seen calls for Judge Sebutinde to recuse herself in regards to the ongoing case of South Africa. I will get to juicier questions in a moment, but for now, I would like Juliette, as our procedure goblin, to explain to us what are the pertinent basically rules, right? What are the rules of the ICJ statutes concerning impartiality and also concerning recusal? And secondly, in particular, if Judge Sebutinde refuses to recuse herself, I would like to know if there is a way for the court to nevertheless remove her from hearing the ongoing case of South Africa against Israel.
Yes, absolutely. Okay, so bear with me while I walk you through a couple of parts of the statute. So we start with Article 2 right at the top, because the statute specifies that the court needs to be composed of a body of independent judges. And so when new judges are appointed to the court, they have to make a solemn declaration, which is along the following lines: I will perform my duties and exercise my powers as a judge honourably, faithfully, impartially, and conscientiously. So this is the promise that the judge makes upon their appointment. This is how they're going to operate. So this is basically our starting point, is that the judge has to be independent and the judge has to be impartial. This is their promise. And so this is something we would expect for all judges. People are pretty familiar with the basic concept that judges need to be independent and impartial, right? The ICJ isn't any different in that respect. And so because of that, yes, the statute does include a process for judges to step aside if they feel like they aren't able to be fully independent and impartial in any given case. And so Article 24 gives us a few steps, basically. And the first and most common is that a member of the court considers they shouldn't take part in a decision in a particular case, and they tell the president of the court this, and they step aside accordingly. So this might happen because they've previously acted as counsel for one of the states in a related matter or even in the same matter, or they may have previously expressed views that indicate there's a potential for bias against one of the parties. So, for example, there were some judges in the Bosnia and Herzegovina and Yugoslavia revision case where some judges had made comments and they were like, no, it wouldn't be appropriate for us to sit here. So they recused themselves. And I think when James Crawford was appointed to the bench as well, there were like a bunch of cases where he wasn't able to act for a while because he'd basically been counsel for everybody, not in the years prior to his appointment. So it does happen. It's not an uncommon thing, right? However, it might be the case that the judge doesn't want to recuse themselves, but there may still be concerns about potential bias. And I'll get into the difference between like actual bias and apparent bias in a minute. But when that happens, Article 24 says that if the president thinks that for some special reason one of the members of the court shouldn't sit, then the president will give them notice of that. In other words, the president will take into account what this judge might have said or what they may have done and basically take them aside and be like, look, you shouldn't be sitting on this case. You would expect normally that the judge would then, think about it and kind of go, oh yeah, actually no, my job is to be impartial and independent. I can see how maybe in this instance that's not going to be obvious, and step aside. If the member of the court, if the judge says, no, I disagree, and the president says, no, I really think you should step aside, and the other judge says, no, I'm not going to step aside, then you end up with a vote being taken by the court. So the court will actually sit, they will make a decision, and they will actually issue an order that will go onto the court record, which says they've said there's no problem here, this judge can continue to sit in the case. So in the Namibia advisory opinion, South Africa tried to have some of the judges removed, and there's an order that says, no, this is, we've made a decision, we don't think there's a problem here as a court, and these judges can sit in the case. So yeah, that's the basic process, which I know everyone loves procedure just as much as me, so I'm sure that was fascinating for everybody.
Can I jump in at this point?
Please.
So it's really helpful for Julia to set out the rules, particularly Article 24, when there's a disagreement between the president of the court and a judge over whether they should recuse themselves, because it was this provision that was at the heart of one of probably the biggest controversies, recusal controversies, which has parallels, or well, not parallels, but which is relevant to Julia Sebutinde, and that's my earlier work on the Southwest Africa cases, which has a lot of similarities with the case between South Africa and Israel, in the sense of the international focus and attention on the issue. And maybe I'll provide some background about that case for those who are not familiar with it, and then explain how the dispute arose, and then how the problem, if you like, with Article 24 of the ICJ Statute, how it was not used correctly in that scenario. So this was a case that was the Southwest Africa cases refers to a number of advisory opinions and a contentious case that was brought by Ethiopia and Liberia against South Africa over its administration of what was then called Southwest Africa, which is now Namibia. And that was because Southwest Africa was a former League of Nations mandate, actually like Palestine, right, in many ways, so they had a different status. And South Africa refused to relinquish its control over that territory after the establishment of the United Nations to have a referendum in the territory, and also was administering the territory in line with its system of institutionalized racial discrimination and domination, otherwise known as apartheid. So this was a contentious case, and they were challenging not just South Africa's retention and failure to decolonize the territory, but also the application of discriminatory laws. Now, the recusal controversy comes up because in the first stage of those cases, Ethiopia and Liberia approached a judge from Pakistan called Muhammad Zafrullah Khan to sit as a judge ad hoc in the cases. Now, Zafrullah Khan was a highly respected figure. He was trained in the UK bar at King's College London and had been a judge in the Federal Court of India when India was administered as a unitary state before partition by the British Empire. He subsequently became the foreign minister of Pakistan, and was very forthright in UN debates in the 1940s and 1950s on supporting self-determination, rapid decolonization, if you like, in many parts of the world, particularly in North Africa and Middle East, including in Palestine. And he had clashed with some of the other judges who were serving at the ICJ in the 1960s, principally Sir Percy Spender, who had briefly served as a foreign minister of Australia and who had spent the 1950s trying to slow down the process of decolonization. So they've openly clashed in debates on Morocco, for example, and other cases of decolonization. And it was during when Zafrullah Khan was approached to sit as a judge ad hoc in 1962. Percy Spender persuaded the president at the time, Winiarski, the Polish judge Winiarski, to write him a letter to ask whether there was not some kind of impediment, some reason why he should not accept to sit as a judge ad hoc, because he had been so vocal in many of these cases, although not specifically on Southwest Africa. And Zafrullah Khan replied saying there was no reason why he should not sit, and he wanted to sit. And then the judge wrote back to him and said, "Okay, if that's your opinion, then we we will accept it." And at this point, Zafrullah Khan seems to have been a bit perturbed about the whole issue. Why are they questioning my impartiality? So he then decided, you know what, I'm not going to sit on this case, and so he didn't sit. So he didn't recuse himself because he didn't sit. And they appointed somebody else to be judge ad hoc. Now, the issue then is that the following year he was elected to become a judge, a permanent judge at the International Court of Justice. And now he's sitting in the court with Percy Spender. And I should have also mentioned that Zafrullah Khan had previously been a judge of the ICJ in the 1950s. So he was Pakistan's foreign minister in the late 1940s. Then he was a judge. In fact, he was the vice president of the court. And then he becomes the head of the Pakistani delegation to the United Nations. And he's basically I think he's elected head of the UN General Assembly the year following the United Nations adoption of the Declaration on the Granting of Independence to colonial countries and peoples. So it's a very heady moment at that time. So in 1963, he's appointed to the court. And of course, at this point, the Southwest Africa cases very narrowly is on the merits. So that the 1962 court decided that Ethiopia and Liberia did have jurisdiction. The case was admissible to proceed to the merits, and it all turned on the interpretation of the dispute resolution clause in the mandate for Southwest Africa. So he's now sitting on the court, and he has to address these issues concerning self-determination and racial discrimination. And it's at this point where the dispute and the issue to deal with Article 24 comes into play, because now Percy Spender is the president. He's the president of the court, and he basically approaches Zafrullah and says, "Isn't there a special reason why you shouldn't sit in these cases?" And Zafrullah basically says, "Well, no, there isn't." And then Spender says, well, we asked you if you wanted to be a judge ad hoc, and you said no. He said, no, that's not the case. I said I was going to join, but in the view of the doubt held by the court, I decided not to. So I never sat in that capacity. So I never recused myself, and I don't want to recuse myself this time. In fact, it's interesting because the literature seems to suggest that Zafrullah Khan recused himself. While I was preparing for this, I looked at the statutes of the International Court of Justice, the commentary published by OUP. There's a chapter by Jennings in it. And it makes a classic mistake where they refer to an order in 1964 where there was a vote to remove one of the judges, but that concerned another judge, Padilla Nerva of Mexico, who had spoken, by the way, on Southwest Africa, but Zafrullah Khan didn't. In a nutshell, what happened is Zafrullah Khan was placed under pressure, and what Percy Spender said is that a majority of your colleagues think you shouldn't sit on the case, and so Zafrullah said, well, let's follow the procedure. Let's call a vote. Let's have a meeting. And so he comes and he gives a statement, and then he retires, and then the meeting takes place. And then Zafrullah says, well, what was the outcome of the meeting? And he says, well, there's a special reason, and in the view of the majority, but he keeps asking who are the majority, and Spender can't tell him who the majority are. And then he says, look, I want you, before I go on holiday, to write a letter with your resignation from the case. So he goes on holiday, he comes back, and there's a 10-page letter from Zafrullah saying why he's not going to recuse himself from the case. And he goes and he cites precedents from international cases, but also domestic cases, including from apartheid South Africa, most interestingly. And he says there's no grounds for him to recuse himself. And Percy Spender, and he points out that, he says to Percy Spender, you yourself were also you were a foreign minister, you were head of the delegation at the General Assembly, you participated in debates on Southwest Africa. Surely, it's a case of the pot calling the kettle black. If you want me to recuse yourself, shouldn't you recuse yourself? And there were also all those judges, by the way, in the 1960s were involved in these. Many of them had been diplomats and held high positions in the state. But the point is that he refused, and then Percy Spender said, no, I expect you to recuse yourself, and he didn't. And then what happens, most astonishingly, is that on the opening of the case in 1965, the first statement he says is that Judge Zafrullah Khan is not sitting in the case. So he basically forced him out. And that's why one of the reasons it was so controversial. And after that, a judgment was issued. Zafrullah Khan gave interviews to the New York Times, to the Observer newspaper in London, and to Dawn, which is a Pakistani newspaper, basically saying he was given no choice. He was coerced. He was forced to leave. So that's one of the difficulties with that provision in Article 24. But I think I've been speaking for too long. I'll let Juliette come in on that provision.
No, it's fascinating, right? Because it's perhaps one of the most controversial cases, also because, for the benefit of our listeners, what happened then is the case goes to the merit stage, and we end up with first, basically initially hung courts, so like both sides have the same number of votes, so it all came down to the vote of Sir Percy Spender because he was the president. And as Victor has also written in previous work, he was also someone with very strong opinions, especially about the relationship between communism and decolonization. He was really worried that if South Africa moved out of Namibia, Namibia would basically become a socialist communist state. And we ended up, obviously, Sir Percy Spender breaking the tie, but also we ended up substantively with this very weird decision because everyone had thought that procedural issues had been resolved in the preliminary objection state, but we ended up basically with the court saying that Ethiopia and Liberia had basically standing to bring a case, but not to obtain, they had a legal interest to bring a case, but not to obtain a judgment, essentially, which was a very peculiar distinction, to put it mildly. So in a sense, besides the procedural messiness and impropriety, it also turned out to be a pretty consequential let's call it recusal or firing or whatever, in sense of a better word, because if Zafrullah Khan was sitting, arguably they wouldn't have been a hang court, and arguably Sir Percy Spender's vote wouldn't have counted double. And that's also a very long answer to the question, why didn't Australia have a judge in the ICJ between the late 60s and the appointment of James Crawford? Basically,
right?
Australia was in the doghouse for a long, long time. Juliette?
Well, and the court was in the doghouse for a long time after that decision too, right? Like it caused huge reputational damage to the institution that took a long time to recover from. But I wanted to just, I mean, I love that story so much. And if people haven't read, we'll put Victor's paper in the show notes because it's one of my favorite articles I've ever read about this story. It's like a detective novel, the story of Zafrullah Khan. But it raises so many interesting issues, right? So the first one is this question of the status of judges ad hoc, because at that initial point when they're saying, oh, it's not appropriate for you to be a judge ad hoc, there's a couple of things. I mean, one is that, yes, judges ad hoc do also make the same declaration that they will be impartial and so on. But part of the reason that you have judges ad hoc in the first place is because there's this whole thing about judges they've got to be born somewhere. They come from certain states. And if a state is a party to a case and there isn't a judge of their nationality on the bench, then they get the option of appointing a judge ad hoc. And clearly a part of the process there is the whole point is they're going to be kind of in your favor, right? Like this is very much a throwback to the old arbitral basis of the court, which is where basically you've got two warring sides. They each pick a person who they think is going to decide in their favor. And then those two people pick an independent third party to be the tiebreaker. And it's not that they're necessarily biased or that they will in fact decide in your favor, because we have seen plenty of judges ad hoc who don't do that. But the point is that you do know this person's work, and that's why you're picking them, right? Because you think that the arguments you're planning to make will probably be appealing to this person based on their previous writings. And so the idea that a judge ad hoc could be forced out or told that it was inappropriate because they had expressed some views that might potentially be in favor of one of the situations, it kind of goes against the entire point of a judge ad hoc, really. But having said that, once they do take that oath and once they're sitting as a judge, they're on the same baseline as all the other judges, which is this emphasis on impartiality and independence. And so what the Zafrullah Khan story is also interesting is this real kind of question of when is it bias and when is it perception of bias, and which one of those matters more? And that might take us back into Sebutinde as well, because for Zafrullah Khan, I think there was obviously a view from Sir Percy Spender that he thought Khan was going to be biased. But as you pointed out, Victor, no more or less biased than Spender himself, right? They had strong opinions on these issues. And so everyone has strong opinions, like lawyers have opinions, right? That's what we do. And so you can't ever get someone who has never expressed a view on anything previously in their life. This person's not going to be appointed a judge. And as you also said, these people always come from foreign affairs departments and diplomacy, or have been professors of international law previously. These people have lived public lives where their views are known, right? So you can't escape the fact that you've got human beings who have proclivities, opinions, and so on, making these decisions. Where impartiality comes in, though, is about the question of what are you taking into account when you're making your decision? And to what extent can you set aside those personal proclivities to actually decide the case on the merits as it has been argued? And that's the real question here. And so you've got either genuine inability to be unbiased because you just refuse to actually take into account the merits of the argument for whatever reason, or you've got perceptions of bias, which is where even though you could do that as an internal thing, you could go, yeah, look, I know I've said previous things, but I'm open to argument and I will listen to both sides equally. Other people who are looking at the court would be like, no, we don't think so. We don't think that's possible for you to do. And so, I wonder, I am not defending Sir Percy Spender and, oh my God, please no one interpret this question this way. But like, Victor, do you think that with Khan, for example, we'll get on to Sebutinde in a minute, but do you think with Khan, like there was ever a risk of a perception of bias? Was where he, I mean, obviously South Africa thought there was because they tried to kick him out of the Namibia one as well.
But South
But
Africa
was there ever
actually,
a real risk?
so South Africa only objected to Zafrullah Khan in 1970, in the 1971 Namibia advisory opinion. And the reason they objected to him is
Yes.
because he didn't accept to be a judge ad hoc in 1962. No, the funny thing is they didn't object to him. In fact, they voted for him for his election. So they didn't, and that was one of the arguments he actually made in that 10-page letter to Percy Spender. He said, "Look, no one's objected. The South Africans haven't objected to me. They didn't object in '62. They didn't object in 1963 when I was elected to the court. They actually voted in favor of me. So what's the basis?" So yeah, and then of course in 1971, the objection concerned three of the judges: the Soviet judge, I think it was Padilla Nova again, and then and Zafrullah
Yeah.
Khan. And of course, by then Zafrullah Khan had come out and made public statements following the 1966 decision. He did speak to the press, so it's slightly different to his situation before. I mean, I think so that article you kindly said you'd share was actually based on a book manuscript. I was actually wondering why I never published it. And that goes into a bit more detail. And Zafrullah Khan had sat as a judge ad hoc in previous cases and had voted, I think, against his own government. So he always gives that as the example to show that he could be impartial and hold different views, and he would assess. I think the important thing is we all have our different views, our biases, but you try to assess the information that's given to you in a case according to the rules in in Article 36, the sources of international law. It shouldn't be extraneous reasons or for why you hold a very strong view, and this might come when we discuss Sebutinde shortly. But I think he could have sat on the case. He probably would have sided with Philip Jessup and Tanaka and the others on the issue. But yeah.
Yeah. So actually, I'll get to Sebutinde later. I think we keep postponing it more and more, but I think you both touched on something that I actually wanted to ask. And my question is how and whether it is even possible to draw a line between partiality and impartiality on the one hand, and on the other hand, what I would say is a pretty naive, but also quite like conservative idea that somehow it is possible to have totally unideological, totally divorced from politics, from morality, from culture, judicial reasoning. Right. So do you think there is a principal distinction to be drawn between those two? And like the way I was thinking about it when I was preparing for this podcast is it possible to draw a line between, let's say, what would be, in my view, an open case of bias in the case of Judge Sebutinde versus, let's say, whether Judge Hilary Charlesworth can sit in a case that has to do with CEDAW, with the Conventional Elimination of All Forms of discrimination against women, in light of the fact that she is a feminist international law scholar, right? And undeniably, she will have views both about CEDAW, but also about the condition of women in the world, right? Both in the case that seems to be going its way through the court that the Netherlands and Canada, I believe, are bringing against Afghanistan, but also in general, right? Is there, do you think, a way of drawing a line between those two, partiality and impartiality on the one hand, and secondly, a sort of like fantasy of a pure and wholly unideological judge who's just a vessel through which the law, quote unquote, presents itself to us?
I do, but I want to hear what Victor has to say first.
Okay. Well, I don't think it's possible to divorce. I mean, we're all human beings. We're all affected. Everyone, I mean, on the Israel conflict in Gaza and the broader decades-long conflict in the Middle East, I think almost anyone has an opinion about something. But I think the difference between the example of Charles was the difference between being an expert and writing a lot about a particular issue and then having a very strong ideological view that you're never going to change your view. You're not open to being persuaded otherwise. You've got this view and that's the correct interpretation, or it's almost like an ideology or religion, and nothing's going to change your view. And then there's the work most lawyers do is you look at the facts, you look at the law, you can argue about different interpretations, but it's the process of how you do that. It's different to saying, no, I have one view and I'm gonna make up facts. I'm gonna make up the law to suit my view. That's something totally different. And I'm going to suggest that's what's happened regarding Sebutinde's, particularly her dissent in the advisory opinion, which I painfully had reread on the train yesterday. But I'll leave that again for.
So I'm going to proceduralize this, right? As is my want, but I actually do think that this is what it turns on, because you're absolutely right to point out that we are human beings and everyone has got their own personal biases. But law is a fundamentally human enterprise, right? Like, we are making decisions about how we want to live in a society and what we think the best version of that looks like. So it's not a bad thing to have human beings involved in this decision. And it's important, actually, that they bring to bear all of their lived experience in these processes, right? Because, the older you get, the more you learn and the more you can take things into account, right? It really comes down to procedure. Because when we say someone is biased or they're partial, what they're doing is they're taking improper factors into consideration here, right? Mm-hmm. So if you are looking at, say, a feminist analysis of CEDAW, that's not an improper thing to do, right? It's a lens, it's a methodology that you can apply to interpret an instrument. It's a legal process, right? And so we say to judges, look, you can have what views you want, but the things on which you're allowed to base your decision have to come down to the material, the evidence that you've been given. Yeah. You can't make up new facts. The law as it exists. You have the capacity to create new law, but we have processes around the way that you can do that as well. And as long as the judges are following those processes, then the intellectual methodologies that they might apply, or even the personal consciousness, or even just their vision for a world. Let's think about, Cansado Trindade and his, very particular way of viewing what the purpose of international law in the world was. That is still an appropriate judicial act, in my view. That is why we have human judges and not machines making these decisions, because that's the whole point, is taking all of these amorphous things, rules and facts, and blending them together into a result that we hope is one which will bring about, a just and, right outcome and a, better world for, forgive me for being, hopeful. So that's the thing, right? It's process.
Very and that is what's
it's very not trendy. It's very cringe. But that's, for me, that's the thing, right? It's about the things that we say, the process tells us that these are the acceptable things to take into account. And there are other things which are not acceptable to take into account. And that might be our in to the elephant in the room.
Yes.
Which we've been avoiding.
Okay. So I think we have been working our way towards the crescendo of the episode, which is what God is telling you an appropriate factor to take into account? Do you think that Judge Sebutinde should recuse herself? And I know Juliette has already written about that in public, so I'll give perhaps Victor the floor first, and then we can go to Juliette as well.
So you won't be surprised to know that I think she should recuse herself. I mean, maybe I should just briefly comment on. Well, I mean, first of all, I guess I wasn't surprised to reread her dissent in the 2024 advisory opinion. And I mean, partly when you say the Lord is counting on you to decide, it's almost like you've given your interpretation of what the Lord is telling you to come up with a particular view. You're not actually applying the law as it should be. But my comments, which I jotted down on the train on my phone, were, I mean, it goes beyond that. I mean, the facts is factually inaccurate. A lot of the things she was mentioning is legally dubious. She had lifted quotes from, very questionable sources. And ultimately, she gives, this is what I wrote, she gave authority to a distorted and aggressive Christian Zionist viewpoint that only one group of people, the Jewish people have rights, have sovereign rights to the land of Israel, which they've had since time immemorial. And this is, I mean, it's just, it's, she didn't cite, there's no evidence to support that there's been a, that is true. In fact, the evidence is to the contrary. I don't even think you need to even get into that. She didn't even need to go into that. But, it's well established. And this is part of the work I was doing, this 400-page petition, which we've presented to the British government, which I drafted with Danny Friedman, Avi Schleim, John Quigley, Ben Emerson, and others, where we are going over the same ground she did, but we're going back to the sources, the archives. We're doing the work you should do. The sources of international law, treaties, judgments of the ICJ, official data. That the population was overwhelmingly more than 90% Palestinian. They were Ottoman citizens. They included Jews at the time. Many of the ancient Israelites had converted to other religions. And so on. And then she goes on to even Ben Gurion accepted that the Palestinian people were the original, the Falahin were the descendants of the ancient Israelites. That's the view he took. I mean, we can dispute all that, but also she also has this view about usi possidetis, which has never been applied. This idea that you inherit the colonial boundaries on independence, which was never argued at the time, has only been argued in very extreme minority writings very recently. And it's also illogical because she mentions the UN partition plan, which had a different border. There were the armistice lines, and the border she says is a border was actually simply a delineation of administrative competence between the British High Commissioner in Amman in Transjordan and the British High Commissioner in Jerusalem. There was no border. And so it's kind of like it's mendacious. It's almost propagandist in the way you see these arguments coming from right wing groups who are propagating expansionist ideas to claim sovereignty to all the land of Israel. And it's disturbing to see a judge give this credence, especially at the International Court of Justice because of the authority it kind of gives that particular viewpoint. And ideally, she should recuse herself. But if that doesn't happen, this is where the difficulty, because it then comes back to the special reason, and then the Japanese president is faced with this difficult situation where it's a woman judge who's from a developing country who's African. It doesn't look good that he's pressuring her to. He might, I mean, if he were to do it, probably the best way would be to have a vote. But that's for reasons we can go into. That doesn't always work out. But I probably said too much, and I'm interested to hear what you both think about this.
Juliette?
Yeah, so look, I mean, my personal view is absolutely right, because there's no question that she has declared. Now, look, here's the thing. It's not that she's not allowed to vote in favor of Israel, right? Like if she takes the law and the merits and the facts into account, and in her view, she thinks that Israel's got the better case, right? I'm not saying that, voting in favor of the respondent in this case is forbidden. That would be just as biased, right? She's allowed to reach that conclusion. The problem here is that she has explicitly said that she will be voting in favor of them before the arguments have even been made. All right, Israel hasn't even submitted its counter memorial yet. So, this is problematic, right? She is clearly not going to, or she has declared her intention not to take into account the merits of the arguments that are being made by both parties in this case. She has decided to favor one of the parties in advance based on her religious convictions. Now, look, she has every right to freedom of religion. She can have whatever personal beliefs she wants to have. Everyone has that inherent right. But that is not on the list of things which we say judges are allowed to take into account when making their decisions. Judges have all kinds of different religions. They are atheists, some are Christians, some are whatevers, right? That is one of the things that we say has to be put at the door, right? It might influence your sort of moral perspective on some questions, but you can't open your religious text or, use that analysis or have the Lord speak to you and tell you what the answer is, right? Like that is just not okay. And so, yeah, it would absolutely be appropriate for her to recuse herself in this case, in my opinion. I do think it's interesting, though. I just wanted to comment we haven't yet seen anything from the parties here. Like we haven't seen South Africa. There might be stuff happening behind the scenes that hasn't yet been made public on the record, but we haven't seen South Africa, ask for her official recusal at this stage. That's something that is open to them to do, and
It could be
they
done
might,
privately.
but they might
They
choose
might do
not
it
to.
privately. Yeah.
Yeah, they might do it privately. Maybe the judge, maybe the president has already spoken to her. We don't know. But I think the other thing I just wanted to sort of emphasize, and I guess this is in contrast to the Zafrullah Khan situation, which is that, if the president says something to her and she refuses to step aside, it would be appropriate for the court to take an official vote and make an order. And really that is the only appropriate next step. And it is, like, as you said, it is a bit awkward perhaps, but I think it probably needs to be done. That procedure exists for a reason, and it needs to be followed, because when you're just putting pressure on people behind the scenes, that's not such a good look.
And something similar happened with the advisory opinion in 2004 on the Israel's construction of the wall, when Israel objected to Judge El Arabi of Egypt. They sent a private letter, and then there was a vote, and ultimately all the judges voted to keep to reject the complaint by Israel, with the exception of Judge Bergenthal of the United States. But what was interesting is the reasoning was because El Arabi had given an interview to an Egyptian newspaper, but before he became a judge of the ICJ. And it was more, basically he said the occupation is unlawful and Israel's creating facts on the ground, which is kind of evident, but was considered controversial 25 years ago, or 20 years ago. But this is different, right? Because Sebutinde has given an interview, or she was quoted in a newspaper talking about an active case while she's sitting as a judge. So it's different to the El Arabi situation, where he had spoken about an issue which wasn't directly relevant because it was particularly about the wall, not the occupation as such. And in this case, where she's come out while she's a judge, while the case is ongoing, and while she's sitting in it, saying that she's following the Lord's will. So that there is a difference. So it's quite unique, actually. I think it's quite unique that I don't think this has happened before, because most of the rules are about what judges did previously and whether there's a conflict of interest, and not while they're actual judges.
Because we kind of assumed no one would do that. This is the sort of thing that we don't have an explicit rule about, because it kind of goes without saying. So, like, for me, what is really remarkable actually about this, which speaks to what Victor said, is, in a sense, saying something like that so publicly, right? Which for me is almost a reason in its own right for her to recuse herself, in the sense that, to me, with the case being ongoing, going publicly, and basically, yes, saying that in a way you're not answerable to the court and you're not answerable to the law, whatever we understand by that, but you're answerable to, like, your Christian Zionist beliefs, and saying, because I think there is even a difference between if she had said that in some private setting and it was leaked. But for me, it almost speaks to an unwillingness or inability to perform the role of the judge, right? And I would be unwilling or unable to perform the role of the judge, just to make that clear. I don't think that's necessarily transcendentally a bad thing, right? I don't think it's necessarily bad to be unable to remove yourself from your sincerely held beliefs. But at the same time, I just don't think that this is something that is compatible with holding judicial office. Right. And that's like why some people might never do that, because they're not willing to even put up the performance of divorcing yourself from your sincerely held beliefs. So in a sense, I almost have a sort of sympathetic almost view to it, but at the same time, a sympathetic view that is not compatible with holding that office, if that makes any sense. If you don't think that the ICJ has any sort of authority over your legal views, that's perfectly okay. I just think it's a bit hard to at the same time be an ICJ judge, or holding that the court and its procedures and it's sort of like ways of reasoning and the fact that you have to write down something that looks like a judgment. If you think that that's not how you exist in the world and understand law, there's just no reason to be an ICJ judge. You can be an international legal advocate, right? An advocate for international law and Christian Zionism. I don't think that's a great thing for one to be doing with your time, but I think that's a perfectly legitimate thing to be doing, or at least it's an available thing to be doing, if not legitimate.
Well, yeah, and so I wanted to just jump in and say, like, I think you're right about this idea that, she's sort of said she's beholden to a higher power that's not the court itself, and I think those are really valid. But for me, I mean, it's almost like I don't really care why she's made this decision. It's the fact that she's made this decision in advance in respect of a particular party. Like, I don't care which party it is or which case or what your reason for doing it is, whether you've been bribed or whether whatever your rationale is. Once you have pre-decided that regardless of the quality of any legal argument or regardless of what the facts are, that you will be deciding in favor of party A, that's it. You're not a judge anymore. You can't be a judge, right? Like you are pre-deciding in favor of one party, no matter who that is. It could be a border dispute, right? I don't care. Like, you could have two states arguing over where the border is, and if for whatever reason one of those judges was like, well, the border has to go here because I like the milkshakes from that country, right? That is not allowed. You have pre-decided based on non-legal factors. End of story.
And maybe I can come in here briefly to talk about also the role of religion, because Sebutinde is not the only judge to have strong religious convictions. Just to bring it back to Zafrullah Khan, he was an extremely devout Ahmadiyya Muslim, and in fact, most of his writings, his non-legal writings, which he wrote quite a lot of, were about his particular branch of Islam, which is controversial because it's seen as a sect that's not an authentic Islamic one. But he spent a lot of his career writing that, but he never brought that into his judgments. He may have formed his worldview. I'm certain it did, but he didn't affect the way in which he approached specific cases. And I suppose he also belonged to that kind of older tradition of basically not writing very long, separate and dissenting opinions. So this became more popular actually interestingly in 1966 Southwest Africa case, where the dissenting opinions are longer than the actual judgment. But it was from that tradition of getting to the point briefly and stating the facts and the law accurately. But the point I'm making is perfectly okay to be devout, evangelical, Catholic, Jewish, Muslim, but at the end of the day, you still have an obligation as a judge at the court to judiciously apply, to the extent that you can, the law to any given disputes.
Yes. So I am going to give you a final substantive question, because I think a consequence of discussing together the recent case and advisory opinion concerning Palestine and also Southwest Africa is that these are some of the most legally but also politically charged cases the ICJ has ever heard, right? And these are also cases in which there was suddenly a broader public interest in the work of the court, which, we don't see very often in Costa Rica versus Nicaragua border delineation cases, right? So my final question, given the high profile of so many cases that are currently pending in front of the ICJ, and is given also how many international lawyers have assumed a role of a public intellectual, right? Speaking in public, also through media, social media, traditional media, to educate the public in international law. Do we expect basically that this is a problem, perhaps not in the most extreme case that we saw in Judge Sebutinde's comments, but perhaps in subtler forms? Do you think that this question of impartiality and recusals is going to become an increasingly central issue for the ICJ over the next few years? And if so, do you think that perhaps it's going to influence, let's say, its legitimacy or its perception, both by specialist audience, let's say international lawyers, but also by the general public?
It's a very good question. I think yes and no. I think it could become a problem in the future, particularly if our generation, the generation coming, who are very social media savvy and very outspoken, were ever to seek high judicial office. But it's no, I will come because I think the kind of people that do tend to be elected judges are the types who spend their careers working for government, where they are basically they can't really say much, or they seek membership of the International Law Commission, and they're basically very close to their governments, and they're unlikely to be the kind of people. They're unlikely to be public intellectuals. So I think the role I have and the role you may have is a different one. As academics, it's our ability to speak freely and openly that's important in any civil society. But for many of the people who are elected to judicial office, they may come from countries where that's not the case, or they just want to be careful precisely because they may be called on to assess disputes that are controversial. In which case, it's better to, say less, shall we say?
And perhaps we can already guess who of the younger generation has such aspirations by observing who is quiet.
Yeah.
Exactly, right? Like there is some truth to that, like I'm never going to be appointed, to the ICJ, let's be realistic, right? Because I've decided that my job is to be outspoken about things in a very public way, and so no country is going to tap me on the shoulder and be like, hey, we think you'd make a great judge. And it's nothing to do, it's nothing, it's just the way it is, right? Like that is just a fact. And I think it's, we obviously do have a lot more people who just get on social media before they necessarily even think about their future careers or whatever. And so some of that stuff might come back to bite them a little bit. What you often see, though, is that people who set their sights on potential judicial office will very deliberately draw back on and or curate their social media. And I'm thinking, domestic judges that I know, the way that they've gone about sort of, getting rid of their social media and being careful about what they say on social media. Because even if you're practicing as a barrister, right, you have to be a little bit careful about the stuff that you say. You can't talk about your ongoing cases. You obviously want to make sure you get briefed, so you don't want to be too necessarily, opinionated about any given thing. So people who are on that career path, I quite agree with Victor, I think are already being a little bit cautious. But on the other hand, we even have some judges who are on Twitter and various things as well. Judge Orescu has a Twitter account. So it's a little bit of a new thing that we haven't necessarily seen before. Will it lead to more recusals though? I don't necessarily know, because at the end of the day, if someone has written something on Twitter at the age of 22 and then becomes a judge at the age of 62, it's not necessarily the case that they are unable to be, judicious in their decision making at that point. I think it's always comes down to the discretion of the individuals involved and the court, and what is sort of appropriate and what is not. So that's my view.
Awesome. Okay, thank you so much, Victor. Before we wrap up, we will absolutely link to your own work, both your work on Serpe Suspender and Zafrullah Khan. But we were wondering if there is anything else you would recommend to our listeners if they want to learn more about any of the things we have been discussing today. Any good reads, any good listens, even like rival podcasts.
On this particular issue, gosh, nothing comes to mind. I mean, there is another article I wrote on this issue on elections to the ICJ. It's like a trilogy that was actually part of a workshop that Hilary Charlesworth convened in the Melbourne Journal of International Law, and it looks at the UK approach to elections, to who they would nominate in the national group. And it does revisit Percy Spender and Zafrullah Khan, but from the internal British Foreign Office justifications for why they would nominate or not support a particular candidate. So it does deal with kind of the racial and bias issues from the internal perspective of a Foreign Office operating in the Cold War. And that's I think that's open access, that piece.
Awesome.
So I can, if you don't have it, I'll send it to you.
I'm sure we will figure out. Juliette, I know you have written for Verfassungsgesetz on the topic. We will also link that. Anything else you think we should read?
There's nothing off the top of my head. I mean, this is what's kind of this is not an issue that comes up often, right? I think, it's one of those things that we just expect judges to follow the principles and follow the rules, right? But there is actually, having said that, there is one piece I would recommend to people, and it's a little bit older, but it's written by James Crawford and Joe McIntyre, and it talks about judicial independence of international judges. And it's a really useful piece. It talks about independence and impartiality and what those concepts mean and why they're important, and all those kinds of things. So yeah, I think that's what I would recommend. And we can put that in the show notes as well. Lots of links for the listeners today.
Yes, we gave everyone a lot of homework. Victor, thank you so much for joining us in the middle
pleasure.
of such a busy time. And thank you for your insight. Thank you as well, Juliette.